I think that the thing that you've seen over the last, not even 10 years, I think the last 3 or 4 years, which I find disturbing, is what I call the executive court, which is the judiciary often echoing the language of the executive. So we don't think of something happening, in an actual area. We don't think of it as being a big problem for us. I think what's different is it's now come home. Given the dilution of powers of all these other bodies that are meant to check executive power and decentralize power, the court remains the only body that exists which has the power to do that. And that places upon the court a very onerous, I think, responsibility to do it.
And welcome to another episode of Table Talk. I am Jyotsna. Well, on the show today is lawyer Gautam Bhatia. He does not fear in speaking out, especially against institutions that many of us will think twice about saying anything on: the Supreme Court and the court. His latest book, The Unsealed Covers, looks at the last 10 years of the judiciary and its interplay with the executive. These have been tumultuous years when the BJP took power and continued to consolidate it. The relation between the executive and the judiciary was one of push and pull. So listen to what Gautam Bhatia has to say about the sanctity of the Constitution and of several other judgments that have impacted us in the last few years, including the UAPA, Article 370 in Jammu and Kashmir, and many more. Watch and hear what he says about this relationship between the judiciary and the executive and whether there is an overreach. Gautam, thank you so much for joining me today. And, it's been a pleasure to actually read your book, Unsealed Covers. I'm going to take a quote that one of your, someone wrote about your book in one of the newspapers, and they've written, "Unsealed Covers interprets law like a lawyer, theorizes like an academic, and rebels like a citizen." Is it the last part that was the toughest?
No, actually, that's, I think, perhaps the easiest part. Because right from the beginning of when I went to law school, we've always taught to be critical in our thinking, in our approach to law, to judgments, and so on. So that was something that was drilled into us from the beginning. And so I think the critique part of it comes easy. I think the difficult part of it is to make it legible for non-lawyers because of the very arcane vocabulary of the law.
You said this outright in the beginning as well, that you are in a sense taking a stand, but taking a stand these days is very controversial for whichever way you take that stand. How did you try and balance that out for the book?
So basically, the way I tried to do it was to ensure that in the beginning, the readers know what my overall position about the law and about the role of the Constitution and the courts is, which, as I've said, is to rebalance the power relations between the state and the citizen, and then to critique the judgment on that basis, and to critique every part of it with transparent reasoning. So I think the readers can make up their own mind if they agree with the presumptions and if they agree with the reasoning.
It's fascinating the decade that you've touched on. It's been the rise of the ruling BJP. It's also been the decline and further decline of any kind of sensible conversation, any kind of mature debates that we could have seen in media or in society per se. How then was it, what do you expect from this book in terms of the learning for the people? Do you expect that same polarized reaction, that comes, that's a default setting in a lot of us now? If it's this way, it is this way, or it's the other way. There's no right of center.
So a lot of the polarization that has infected the political discourse has also crept into the law as well, and into people's engagement with the court. So one thing that people keep saying is that when the court passes a judgment that you like, you praise the court. And when the court passes a judgment you don't like, then you say various things. And I think there are two ways to ensure that doesn't happen. One is to obviously be honest and also critique the court when it does something that you approve of in terms of outcome, but uses insufficient or inadequate reasoning to get there. The second, of course, is to be sober in the critique, which is that one very common thing people immediately go to is, oh, judges are sold out, judges are this, judges are that. So basically, I mean, not to play the person, but to play the ball, right? So just to focus on the reasoning of the judgment, and whatever that reveals about the judge is something for people to make up their own minds on. So I think the only way to at least in the legal discourse, to avoid this kind of polarization is to, I think, stick to these two principles. Whether it will work or not, I don't know.
Now that we're bang in the middle of elections, do you see any kind of role for the judiciary at this point? I mean, there's been a lot leading into the elections, but we've seen incidents like what's happened in Surat, where all the candidates have withdrawn their candidacy, and the BJP candidate is already a similar incident in Indore. Can we expect any kind of activism or any kind of resorting to the judiciary at this point?
I think so. The recent conduct of the judiciary in respect of basically being the umpire for the political process is not really filled one with confidence. The classic example of this is the Election Commissioners Act. So last year, the Supreme Court had passed a judgment, a 5-judge bench, saying that the default method of appointing election commissioners, which was the president appointing election commissioners, which means in our system the executive, is unconstitutional. And until Parliament passes the law that remedies the situation, the court set up an interim arrangement, which would be a 3-member commission of the Chief Justice, the Prime Minister, and Leader of Opposition. In December, Parliament passes a law where it effectively hands back control to the executive by having this 3-member committee where 2 are of the executive, the Prime Minister and 1 cabinet minister, and 1, of course, LOP. And then 2 of the 3 election commissioners are appointed on the basis of that new system. And this was challenged in court right after it happened in December, on the basis that the entire purpose of the court's previous judgment was that whatever law Parliament passes will have to secure the independence of the election commission, and therefore executive cannot dominate in the appointments process. Unfortunately, first of all, the court footballed it a few months down the line, and then they say, it will cause havoc with the elections process, so we won't interfere right now with this law, which they themselves had delayed for a few months, hearing, and it was very clear that the law is contrary to the Supreme Court's own prior judgment. So, of course, that is one example. The other example is the EVM VVPAT case, which, again, not to go too much on the outcome of the case, because that's debatable. But if you look at the way that other courts across the world have handled these kinds of disputes, it's taken much more seriously, and they have certain principles. Other courts, transparency, verifiability, accuracy, and so on, and they try to ensure that the elections process adheres to those principles, even if it might take a little longer, the counting process. Whereas what you have here in the Supreme Court's order is a very lackadaisical engagement with the issues.
This whole standoff between the judiciary and the executive, or the clashes between, or that uneasy relationship that the two have, it's not new, is it? But in the last decade that you have written, the essays that you've compiled, what kind of a change have you noticed?
The space that the judiciary has is always inversely proportional to the executive strength, right? So then this is not just India, this is across the world. It's also in our history, in the Indira Gandhi era. But basically, the stronger the executive, the weaker the judiciary, or well, not weaker might be the wrong word, the less space the court has to operate. That's sort of standard. I think that the thing that you've seen over the last, not even 10 years, I think last 3 or 4 years, which I find disturbing, is what I call the executive court, which is the judiciary often echoing the language of the executive. So, for example, when adjudicating the FCRA case, the FCRA Act, which limits funding NGOs can receive, you have the Supreme Court just echoing executive language, the effect that why do NGOs want foreign funding? They should, be strong and get their own funding from India. So just language that has no place in a judicial opinion, and language that is reminiscent of borderline demagoguery, actually, in a certain sense. In the Teesta Setalvad case, again, the Supreme Court, when dismissing the petition to reopen the Zakia Jafri investigation, it then passes comments against Tista Setalvad, and then she's actually arrested the day after and spends a few months in jail. So I think those kinds of comments and observations, that is not just the Supreme Court or the courts not being able to be assertive against the executive, which I think is understandable, and it is difficult in a time of an assertive, strong, an aggressive executive. It is very difficult. So, we all understand that. We don't expect activism in a time like this. But this sort of being in lockstep with the executive language, I think, is what's new and a little disturbing.
In the last few years, I think it's been coming, and especially it's caught up in the last months or so, the whole debate around the Constitution. And I just, the tagline of your book, Gautam, says a decade of the Constitution, the courts, and the state, right? Now, you also write where you feel that the Constitution is a contested terrain.
A, by guaranteeing rights, and B, by creating institutions among which power is distributed. The Constitution attempts to ensure that no one person can control everything and therefore subject people to an arbitrary tyranny. Every case that comes is basically a case about this, ultimately. Every constitutional case ultimately is about whether we will centralize more power, whether we will decentralize power.
This definition that you give me, how much of it is under threat at the moment, Gautam? How do you see it?
So I think it has been, so in fact, the book I'm working on right now, the next one, actually, it argues that there has been a centralizing drift in our constitutional interpretation from the beginning. And many of the things that we are seeing now are actually, just culminations of that drift, or taking that drift further, but in a more intense or a more accelerated way. So, for example, you have issues around the way governors act, the way governors basically in states are acting in a partisan way. Well, the very first election after independence in the Madras presidency, actually the Congress party was the second largest party. It wasn't the largest party. And Rajagopalachari was the governor, and he did some shenanigans of the very similar kind that we see now. And the Congress party then formed the government. So it's been happening from day one of the Constitution. This kind of centralizing, drift has been happening since day one. I think that what you have seen last 10 years is an acceleration of that. But I think then we need to not just look at the last 10 years as, a rupture or as something disjunct from what's gone on before, because all of the constitutional tools that the present executive is using have been created, honed and perfected by previous executives. There is little that is new in that sense. So we should take a deep look at actually our entire history and not just the last 10 years to really understand what the issues are and how in the future we can try and contest this kind of centralization that's been happening from the beginning.
We're talking the constituent of the Constitution. You've written about this as well, but state surveillance, data privacy, profiling. Does that fall into the right that a Constitution gives us to argue and stand up and say this is not okay, or is this par for the course?
There is a constitutional right to privacy. It is not expressly in the Indian constitutional text. It has been read into the right to free speech, freedom of association, the right to life, and so on. So there is a right to privacy. Now, of course, what that right means is of course subject to contestation. So does that right mean that the state cannot compel us to participate in big information systems like Aadhaar? That was the question before the Supreme Court, which I discussed in the book. And the Supreme Court says, yes, subject to certain safeguards. So that has been the contest throughout. So does our right to privacy basically give us an opt-out from these data regimes? And, what kind of body should we have to protect those rights? So the Data Protection Act sets up an authority whose task it is to protect the right to personal data. Unfortunately, that body is appointed by the executive. It's not independent in that sense, unlike bodies in other countries. So that's some of the broad issues that arise in privacy and data protection and so on.
One of the things that you begin your book with, Gautam, is the UAPA, or the Unlawful Activities Prevention Act. And it's been much in the news, especially when it comes to journalists and unlawful detention. Is the overreach of this act as we think it is, or is this something that you've seen governments do it again? It's like I said, again, it's par for the course, or is there something abnormal?
The UAPA, the Unlawful Activities Prevention Act, the purpose is to combat terrorism. And there is a section in it called 43D5. And what 43D5 says, and I'm simplifying it, in layperson's terms, is that when you apply for bail, if the judge believes prima facie that you are guilty of the offense, then the judge cannot give bail. Right? So you have to establish that you are not guilty of the offense at that stage. Now the problem is that at that stage, at the bail stage, the only material that the judge has is effectively the police version, the FIR, maybe the charge sheet, maybe the section one, what they call section 161 statements. So it's basically the police documents. And so unless the defense at that stage cannot raise its own arguments, it can't bring its own witnesses, it can't cross-examine the prosecution's witnesses. So basically the defense all it can do is poke some holes in the prosecution's police case, which unless the police are completely incompetent, they will establish at least a basic case, and then you basically can't get bail. And then you stay in jail for whatever time it takes to be released, which could be 10 years, 15 years, 20 years, because these cases will have 200 witnesses, 5 charge sheets running into 10,000 pages. So by the time you get through it all, it's 20 years, and you've basically lost 20 years of your life before you're acquitted. Now, again, the interesting thing is that the language of 43D5 is not new. You first see a variant of it in 1898, the colonial British legislation. You then see the exact wording that is there now. You see it in 1942, when World War II is going on. The defense of India rules are passed by the British. You see it there. Independence happens, and then there are problems around black marketing and hoarding of essential items, because this was just after independence, and there is a food shortage and so on, and people are engaging in black marketing and hoarding to drive the price up. To combat that, they again put in this kind of a bail provision under the Essential Supplies Act, and so on. So it becomes this standard feature in our laws, in our so-called special laws. So that's actually been a problem in India for the last 126 years. We have independence, we have a constitution, but our legislators and our constitutional framers just replicate the colonial weapons, and the courts accept them. The courts, of course, what we have seen in the last few years is it has been wielded in an indiscriminate fashion against political dissenters in a way that it perhaps wasn't being done. And I think it's come into the heart of our discourse. It's come into, so you have people in Delhi being arrested, whereas perhaps earlier you'd have it in, say, places where, Naxalism was there and so on. So it felt a little far away. And I think since we're all a little blinkered, right? So we don't think of something happening, in an Naxal area. We don't think of it as being a big problem for us. I think what's different is it's now come home. Whatever begins in the periphery, I don't mean this in a pejorative way, periphery in the sense of away from the capital and sort of the core urban areas, ultimately will come home. So I think it's a good lesson to be, to always be fighting these kinds of draconian laws.
I'm quoting you. I should have done this when I asked you the question. Accused counsel have to argue as if participating in a swimming competition with their hands tied behind their backs.
At the bail stage, you have to prove you're not guilty, but you can't lead your own evidence for that. Right? So you have to prove you're not guilty just by looking at the prosecution's case. And it's just very, very hard to do that.
But also, you also write about Article 370 and, Kashmir.
Yeah.
And you speak about how, the legal arguments, in a way, were drowned in front of whatever took place.
The judgment came after the book was published. And I think the judgment sort of shows you the complete drowning out of the legal arguments with the political imperative that the court saw in not disturbing what had happened. Let me just put it that way. Because the court believed, and this comes through in the judgment, that this was in service of integrating Jammu and Kashmir with the Union of India. By integration, they meant bringing the state on an equivalent basis with many of the other states of the Union. And to do that, actually, the interesting thing is that because the procedure adopted by the executive and the parliament was clearly so irregular that even the court said that the way they did it was not legal. But then the court said there was another way they could have done it, which is the president could have issued a notification doing it, and that way was legal. So given that there was a legal way to do it, and because it was in service of integration, the court upholds, the action. Again, simplifying it has many things. Which I think shows you the way the outcome that the court thought was a good outcome, then defined the way it approached the process. in which it was done. And I think that's a classic case of, I think, the politics of a case submerging the legality of it.
When you're writing about people like Safura or Omar Khalid, do you put your lawyer persona or your writer persona to the side sometimes and just say, hold on a minute, what really went on here?
So Umar's actually been a friend. I began actually my office was representing him in the first edition case in 2016. So I got to know him at that time, and he's been a friend. And Safura is someone I've known after she was released, not before. And obviously these are human beings, and there's a famous line by an American legal writer which he says that legal interpretation takes place in a field of pain and death. So every time you're interpreting a court is interpreting provision, somebody's going to suffer as a consequence of that, right? And you can't ignore the human aspect of it when you're writing. So it's always there in your mind because what you're doing is analyzing, the case. And impactful legal analysis normally, requires you to try and take yourself out of the situation.
In the last decade, that decade that you touch upon, Gautam, we've also seen key institutions, they more or less become an extended arm of the government.
Yeah.
Where then does the role of the judiciary fall?
So then the judiciary's role becomes even more important because for various structural reasons, for instance, Parliament, which is the third, executive, parliament, judiciary are supposed to be the three wings of state. Parliament is effectively a rubber stamp these days. And that's not because of individuals, it's because of the way the constitution is structured. So, for example, the speaker is not neutral by design, anti-defection law operates, and so on. So Parliament lacks an independent, way to check the executive. And similarly with what we call fourth branch institutions like the Election Commission and so on. So in that context, given the dilution of powers of all these other bodies that are meant to check executive power and decentralize power, the court remains the only body that exists which has the power to do that. And that places upon the court a very onerous, I think, responsibility to do it in a way that respects the division of powers in the Constitution.
I think as a citizen, we've also got to check our expectations, because you also mentioned a checkered list of chief justices in a sense, right? And their history. But you've also written, when there is an emergency, the state gets away. And that's a heavy burden to bear for judiciary, for society, for everybody that is not the executive.
One thing that's happened over the last 30 years of the PIL era has been an over-dependence upon the judiciary to sort out issues. And I think that if there is perhaps one good outcome over the last 10 years, is that hopefully people have learned that the judiciary cannot solve your problems for you. It has an important and crucial role as a referee, as an umpire, as a neutral arbiter between the state and the individual. But it can't solve social problems at the scale of the nation. Using that, revive a more populist, and I don't mean populist in a bad way, but in a good way, constitutional tradition where social movements of the kind that gave us the RTI and the Forest Act do not seek to rely upon the court, but seek to rely upon their own understanding of the Constitution to try and push for legal reform. There are limitations to what you can achieve through the vehicle of courts and litigation.
And what is it that the judiciary can really do to change that image where a lot of people are frustrated?
When everyone can see that you have a frivolous or a made-up case, for example, the Umar Khalid bail judgment in the High Court. If you read the judgment, you can tell that this is completely cooked up, right? If the judiciary, does not intervene in what is very, very clearly and evidently an abuse of state power, then of course people will start to question. There are certain low-hanging fruit, very obvious bail cases, where the court should intervene, and that could at least go some way in restoring that balance, which we have lost a little bit.
I'm going to end with these lines that you've written. Great cases are always 4-1 in favor of the state until the one is resurrected and becomes the pathway for a future that is still struggling to be born. So we are going to leave this conversation on that positive note. Gautam, thank you so much for speaking with me, and many congratulations on your book.
Thank you. Thank you so much. Thank you.